Good afternoon, everyone, and welcome to the Fraud and Commercial Loan Transactions Post-Judgment Legal Strategies conversation. I want to welcome everybody, and you're in for a great conversation today. First, we're going to go over a few rules or an overview of certain topics, and then we'll dive right into our panel presentation. Some housekeeping notes. Everyone is muted right now. You should see a question and answer box that you can submit some questions into as we're going through today's conversation. Last time we were able to address some questions at the end, so feel free to submit those questions. And I'll remind folks at the end, but if we don't get to your question today, we will reach out to you because the software specifically tells us, who had a question that was posed that may not have been answered. After the presentation today, you'll be given a copy of this slide deck, which is limited because today is really just a conversation. But you'll get a copy of that in your inbox, along with a survey. And we always are looking for feedback from our attendees. So if you can take the 3 seconds to fill that out, we would greatly appreciate it. So with that, I'm going to go over a little bit of our presentation that we have for you today. As you may recall, some of you may have joined in on the prior sessions for this conversation, which has really been broken down into 3 parts. The first part being the identification of a fraud within the context of a commercial loan transaction. So in that first webinar, which all these are available on Baker Donelson's websites, we discuss what happens when a lender identifies a possible fraudulent transaction and the scope of what that lender does with conjunction with counsel as to pre-litigation investigation. The second webinar focused on what happens when litigation is actually filed, a lawsuit that may allege, among other claims, fraud and the types of issues that can come up in that litigation. And so that webinar is also available online. And then the third webinar that we had focused on post-judgment transactions and issues. And so that is discussing once your lender has a judgment in hand as a result of the litigation, what can happen and some best strategies to employ. Because we had so many topics to discuss within the post-judgment context, we broke that discussion into 2 parts. So this is part 2 of part 3. And so today, just like the last time, I will be your moderator. I won't go into everybody's bio in full detail again because you've already heard from us once, but as a reminder, I'm the assistant managing shareholder of Baker Donelson's Atlanta office. By way of background, my practice focuses on creditor rights in a variety of contexts: bankruptcy, insolvency, and commercial litigation. And over the past about 7 or 8 years, a large focus of my practice has been on representation of creditors within the context of commercial loan defaults, with fraud as a major component. With me today, I have Lacey Rochester, who's also a member of Baker Donelson's Corporate and Restructuring Bankruptcy Group. She is practicing out of our Baltimore, Maryland office, but she also comes to us from previously practicing in our New Orleans, Louisiana office. Lacey helps her clients formulate practical legal solutions to resolving the challenges of distressed business dealings, and she has extensive experience with bankruptcy proceedings and complex commercial workouts. Additionally, I have my colleague down the hall, Kevin Stein. He's licensed in Georgia and North Carolina. He's also a member of the Baker Donelson's Corporate Restructuring and Bankruptcy Group. He assists clients throughout the United States, including lenders and servicers and other financial services company looking to assist with contract administration, risk management, loan workouts, litigation, and bankruptcy cases. And last, but certainly not least, we have Judge Duffy. William S. Duffy Jr. retired in 2018 from active service as a United States District Court judge for the Northern District of Georgia from 2001 to 2004. Before taking a place on the federal bench, Judge Duffy served as the United States Attorney for the Northern District of Georgia. Before that appointment, he was a partner at King & Spalding. and he left practice to serve as deputy independent counsel in charge of the Arkansas phase of the Whitewater investigation. He has a graduate degree of Drake University and received his JD from the University of South Carolina Law. A frequent presenter at legal conferences and seminars on professionalism. I personally have heard him speak. He's wonderful. Judge Duffy's book, The Significant Lawyer, The Pursuit of Purpose and Professionalism, was published, and he often speaks about that topic. He's working on a separate book, a second book now, on the professionalism in litigation, and he's currently pursuing a master's in theological studies. So with that, we will dive right into our panel presentation. And so where we picked up last time was sort of what our lender clients might do immediately upon getting a judgment. And to recap, some of those things we're discussing basically a quick asset search and sort of the different ways you can employ asset searches and recording of various liens. And so we wanted to address sort of the immediate actions. And now we're going to focus on sort of the longer play here with judgment creditors as to what we can use to sort of gain leverage and information about assets that you might otherwise look to levy or use as leverage within your settlement negotiations. So within that context, I'll start with Lacey. And I wanted to talk about discovery tools that you might employ, Lacey. Specifically, when we think of discovery, post-judgment discovery tools, what type of written discovery can be used to gather information and apply pressure for a potential settlement down the road once you have sufficient amount of information? Lacey, you might be on mute, so I'm going to unmute you.
Louisiana and Maryland allow you to...
Can you start over, Lacey? I think you might have been muted
Can
at the
you hear
beginning.
me now?
Go ahead.
No problem. I said most states, including Louisiana and Maryland, do allow a judgment creditor to employ the same types of written discovery that they could use in the case in chief. So interrogatories, requests for production of documents, subpoenas to third parties, all of that is at play. And not only can you do that in state court, but also I've had success doing it in federal court, because you can issue federal discovery or pull from state court rules if you'd like to employ those in federal court. In my experience, the issue that you sometimes run into when you're using written discovery to gather information that will be useful in levying on assets of your judgment debtor is how present has the judgment debtor been throughout the case. If, for instance, you just got done litigating a case where counsel was involved, or even litigating against a judgment debtor that was very active and responsive, maybe you've got an email address now for this judgment debtor, that might be the type of case where it makes sense to issue written discovery because you're likely to get answers. If you, for instance, issue document production requests in a case where you got a default judgment and you haven't heard anything from this judgment debtor, there's a good chance you're still not going to hear anything from them in the form of responses to your written discovery. And so in those instances, sure, you can go back to court, you can file a motion to compel, get an order granting your motion to compel. And if the judgment debtor at that point does not respond, sometimes they do, most times they do not, then you can go back to court and get sanctions hold them in contempt and effectively get sanctions for their failure to respond. The problem with that is, at least in my experience, really you've got two remedies there. You can get a money judgment for your attorney's fees, which doesn't really do you a lot of good. You're kind of in the same boat as where you started, with a piece of paper that says you're owed money that you're not able to enforce. Or sometimes you can get a writ of attachment to issue against the person. We have employed that successfully at Baker Donelson. I find that it's much more successful in federal court, ways of finding people and hauling them in. They will literally incarcerate these folks until they have an opportunity to go before a judge and explain why they didn't respond to your discovery. And the judge, in my experience, will not let them go unless they promise that they're going to purge their contempt. That that can be a very effective written discovery against a debtor that has not responded. State court, sometimes you're not as successful. Picking on Louisiana for an example, the sheriffs will go out because that's who in the Louisiana state court system enforces these types of orders. And they're not very aggressive about finding your judgment debtor. They'll go knock on the door, and if no one answers, that's the end of it. So a civil contempt order in a Louisiana state court doesn't really have a lot of teeth to it if it is involving the sheriffs having to go out and find someone and arrest them. So I say all this because when you're evaluating what makes sense, you're already out of the money, you're already owed a money judgment. Sometimes written discovery, when you've got someone responsive on the other end, is absolutely worth it. But if not, maybe you should skip ahead and try a deposition. One fun fact about Maryland that I've learned now practicing up here is Maryland makes it easy for a judgment creditor when you have a debt against an individual, a guarantor, for instance, or a principal of a corporation. The clerk there will issue a judgment debtor fact information sheet, and the judgment debtor is required to respond to that. It's a form that Maryland has that gets into the specifics as to assets, value, wages, liabilities, whether or not there's co-debtors on any obligations, and it requires the judgment debtor to produce a tax return, some bank statements, pay stubs, stuff like that. If the judgment debtor responds to that fully and truthfully, then the judgment creditor cannot employ any other types of written discovery or even examination of the judgment debtor for an entire year, unless the judgment creditor can show cause. The most common example of cause being, we have reason to believe that the judgment debtor has not been truthful in its responses.
All very helpful. Thank you, Lacey. Before I move on, I had a couple comments about that. Kevin, do you want to give your experience with regard to pursuing non-compliant judgment debtors?
Yeah, Lacey was explaining, when you have a judgment debtor not answering post-judgment discovery. I was listening to Lacey discuss, seeking contempt or monetary sanctions. And I totally agree with Lacey that sometimes monetary sanctions feels toothless because the judgment debtor already owes and is not voluntarily paying X dollars, whatever the judgment may be. So to get an award of attorney's fees, for example, is just merely increasing the unsatisfied debt. On the contempt side, I totally agree with Lacey's comments that civil or criminal contempt can get the judgment debtor's attention. One trick here is when you're talking about a corporate judgment debtor, you can't put a company in jail, for example. So I try to be mindful when fashioning an order to compel, and I'm thinking ahead of potentially seeking contempt if the judgment debtor does not comply with an order to compel. I'm mindful of whether or not I can persuade my judge to issue the order to compel, not only to the corporate judgment debtor, but to certain specific individuals who, speak or act on behalf of the judgment debtor. So that could be, for example, an order directing the corporate judgment debtor and the officers of the company on notice of the order who are in possession of or have access to the corporate judgment debtor's records to produce those records in response to our discovery. And that way, if there's non-compliance with that order, I can ask the judge not only to hold the company in contempt, potentially to hold individuals in contempt. And that's where the individuals become concerned about going to jail.
All good points. I will say in my experience, I believe Florida also has a similar post-judgment information form that judgment debtors must complete, and a failure to do so can lead to contempt proceedings with the judge and possible incarceration. So if you have a matter down there, I think that's a good leverage tactic down there as well. And I will say from my experience, building off of what Lacey mentioned, I think state court proceedings or the equivalent of that at your state court level in states is it depends on your judge largely on and your county and all those considerations as to whether and how much enforcement you'll get from a judge on lack of compliance. I've found that when we are in district court and federal court, the matters get resolved much faster. So, clients have preferences about whether they'd be in federal court or state court. I will say that on the post-judgment aspect, I find federal court to be much more friendly from a judgment creditor perspective. Okay, so I think we just discussed, we focused on, not I think, but we focused on, the pursuing discovery against a judgment creditor. How about pursuing post-judgment discovery against a third party, which is often where I find you'll get the fastest response from your judgment creditors once you start serving discovery to spouses and business partners and schools for tuition records, et cetera. So Kevin, do you want to touch on whether you find that effective and sort of recommendations and considerations you might have with regard to third-party discovery that's been helpful in your practice?
Sure, happy to. In fact, I would say one of the more common types of post-judgment discovery we focus on is serving subpoenas to banks and financial institutions. Oftentimes, our lenders have an idea of where, sometimes, as you know, the judgment debtor banks with the judgment creditor, or did bank with the judgment creditor, if the judgment creditor happens to be a banking institution. But even without that, relationship where the judgment debtor has a deposit account with our client typically knows at least one bank where our judgment debtor has maintained accounts. So that's usually one of the very first places we'll target for third-party discovery. We will ask for, the typical requests we ask for are the monthly statements, the wire records, deposit records, canceled checks, signature cards, account opening paperwork, for each account, individual and joint account of our judgment debtors. And that could be individual and corporate judgment debtors. And then we'll typically ask for what we describe as signer accounts. So if we have a judgment against an individual, we'll say, not only we'll ask the banking institution produce those accounts in the name of the individual, but also produce the accounts of any other non-debtors if our judgment debtor has signer authority for that account. We call those signer accounts for shorthand. One trap to avoid, states often have privacy rules independent of any protective orders your judge might issue. And so what we typically do to navigate those privacy rules is we will serve a copy of the discovery on any known companies that are not or individuals that are not subject to our judgment, but we know we're going to be asking for their account records. So they have noticed that we're seeking those account records and have the opportunity to object or seek a protective order or whatnot. In those instances where we don't know if our judgment debtor has signer authority for any particular corporate accounts, we will cooperate with the banking institution and advise them that if they need to give notice to any account holders before they produce the records, we're not going to object to that. Other common categories of third-party witnesses in our world, CPA firms, tax preparation firms. If we know that, for example, our judgment debtor has a relationship with a particular CPA firm, whether it's for audit or tax or any other accounting service, we will serve a subpoena. We're very careful to ask for the business records. Most states have an accountant-client privilege, at least the states that I've looked at have some form of accountant-client privilege, which is not totally different from an attorney-client privilege. It's not apples to apples, but it does protect some forms of communication between the CPA and his or her client. So we're very careful in asking for just the business records of our judgment debtor that happen to be in the files of the CPA firm. And we do the same thing with law firms. We've served many, many subpoenas on law firms that we know have had relationships with these judgment debtors. For example, we've served subpoenas on law firms that represented our judgment debtor in the pretrial phase. And what we'll ask is one thing we'll ask that we think is on the right side of an attorney-client privilege. We'll say, we don't want communications with your client. We don't want privileged information. We do want records that sufficient to show the dates, dollar amounts, and sources of payments you have received during your engagement with ABC company. And we take the position that the payment records, a check that would tell us what bank, for example, the client or this law firm's client used to pay this law firm, would be discoverable and would potentially lead us to a bank account that would be available to satisfy the judgment in whole or in part. Co-owners of businesses are also common categories of witnesses. If it's a closely held company, 2 or 3 owners, and we get a judgment against one of those owners, we may look to the other owners for information relating to our judgment debtors' equity in the company, distributions to that company, and so forth. And then another common source of information is a spouse. Spouses, the knee-jerk reaction when we serve a subpoena on the spouse is that we are harassing. Our typical response is that a spouse, whether or not he or she is responsible for the debt, let's assume the spouse is not a co-obligor, but just happens to be married to our judgment debtor, we take the position that that person is well situated to comment on the assets, income, liabilities, and expenses of our judgment debtor. If that discovery has the side benefit of pressuring our judgment debtor to become quote unquote resourceful and find a way to make an offer to us to settle the judgment, all the better. But we take the position that spouses are fair game in post-judgment discovery. And there's a whole long list of cases discussing, motions to compel, motions to quash these kinds of subpoenas, and the parameters of a judgment creditor seeking discovery from the spouse. The one thing I'll tell the group to be mindful of is most states also have some form of spousal privilege. That spousal privilege is limited. It doesn't mean generally that the spouse cannot be compelled to testify at all, but it may protect communications between the husband and the wife, and it may be something we have to be mindful of when we're questioning that spouse or seeking documents from that spouse. But nevertheless, much like serving subpoena on a CPA firm or a law firm, there is certainly an appropriate level of discovery from a spouse that can lead us to discoverable information.
Yeah, just to jump in for a second, Kevin, I totally agree with the comment about sending a subpoena to the CPA. How often is it that you have a company that says, I went out of business, I have no more records? And so you can get, if it's good enough for the tax returns, it's good enough for a federal judge. So, in tax returns, we'll have a lot of these, we'll talk a little bit later about fraudulent transfer statutes, but they look at sometimes insolvency of your borrower. So you have to prove the insolvency. And on tax returns, there's information that can help your expert establish insolvency. We've had to do this recently with the case. And if it wasn't for being able to get those records from the accountant, we would not be in as good of a position as we are in now.
Agreed. CPAs are often a treasure trove of information. And I will say, often Kevin laid the groundwork for getting information from spouses, but certainly your borrower or their business records, to the extent you find a single transfer to a spouse or an entity, owned or controlled by a spouse, that certainly helps support your, and any rebuttal argument that the spouse would try and, quash that information, that you have at least one evidence of one transfer, in addition to the general theory that a spouse helps know, the general spending of a judgment creditor. I will also add, with regard to billing records from attorneys, that is certainly very valuable, especially in a case that, lasts years, and that your bank is spending thousands, perhaps close to millions of dollars, pursuing this. If there's an active defense by one or more on the other side, we should be entitled to know how that defense is being paid, in the post-judgment posture. So with that, we'll jump into, we have such a, expert here that has seen these issues come up before him. And so I wanted to tap into Judge Duffy's expertise while on the bench, with regard to non-compliant judgment debtors or third parties. So Judge Duffy, creditor lawyers are often used to non-cooperative judgment debtors and affiliated non-parties, especially in fraud cases. When you were on the bench, what's the most effective way that you found for lawyers to present these types of non-compliance issues to you?
Well, I do want to back up a second, because I know that you're covering options that you have, but I want to get practical about the options. One is, I think for at least 4 or 5 occasions there were comments about filing motions, and I've always wondered, when I'm on the bench, I know what the turnaround time is to fully brief a motion before I even looked at it. And it has 2 components to it. It takes a long time. I mean, so if you file written discovery and somebody objects to it, they have what, 30 days to object. I can't. It's either 20 or 30. Then you get your objections. It goes back to the serving party. They have to decide whether or not they're going to file a motion to compel. The turnaround time for that is another 45 days or so. So just on a single written discovery request that's resisted by the other side, and I would say that you're dealing with people that are heavily into resistance. So they're not going to say that, you're right, you're entitled to that. Why don't you come over and look at it tomorrow? That it's a process in which they're going to try to make it difficult. And so we've now talked about 2 months just on a single motion to get a resolution. And then I will say the last thing I want to do is to decide a discovery motion, because if it's hard to decide those on the papers, I generally would hold hearings. And the hearings were generally long and contentious, and I would sit back ultimately and say, well, what is it that you really want, and what is it that you will give if it's something I determine to be reasonable? So we would end up with me basically acting as a mediator as far as whether a request was reasonable, and then whether or not a resistance to the request was valid and reasonable. And often through that process, everybody would say, well, that's really what we need. And the other side would say, well, that's, I can tell you how hard it will be to get that, but we have to do it in 2 stages. And in a matter of about 20 minutes, we resolved the issue with the understanding that if they didn't think they were getting what they wanted, or there was resistance in the process, we would have a telephone conversation and generally finesse it some, because something came up that they didn't expect. Now, I don't know exactly who's on this call, but anybody who thinks about what about this briefing schedule on a single discovery motion, what's that going to cost me? It's going to cost you a fair amount of money. So what you want is you want to collect on a judgment. The lawyers want to help you collect on a judgment, and they want to do it in a way that's cost efficient for the person who's paying whatever the legal bill is with respect to that. And you want to create relationships between the court and the parties that will facilitate on in the future the resolution of similar issues. So because I didn't like discovery disputes and certainly hated deciding them on motions, what I would do is I would tell the parties when we got to a stage like this, be reasonable and think about what it is that you really want. And you don't want to see all the documents about all the accounts. If the bank accounts, only of the 7 bank accounts, only 2 of them are really germane. So we could have a conversation, and if a party said, well, we want to see all the bank accounts that they have, checking and savings and investment accounts. And then we would have a conversation about whether or not those were accounts that were reasonable to see. And if there was an account that somebody had because their son used it when they were in college, they'd say, well, we don't really need to see that. And if there's some lawyers that say, well, we just want to see everything, I'd say, well, why don't we take a representative sample of the statements from those accounts, produce those within 10 days so that they can agree with you that they don't want to see that account in the underlying documents, and focus on the ones that will be meaningful to everybody. And I would say that after we would have a conversation like that, and sometimes we'd have a conversation, I'd say, I'll give you 10 days. You work out what it is that you think you really need, what it is that you can provide under what timetable. And if you have a problem, call me back and I'll resolve it. And I think that I think I was a pretty average district court judge, that if an approach was made to me that we can avoid a lot of litigation over motions to compel, then we would have a conversation knowing that we could spend an hour on something rather than 4 days on something. And I think sometimes lawyers have to take a step back and say, in the real world, talking to my clients, where is it most likely that the information is going to reside? Or if we don't know exactly what they have, what are the questions that we want to ask? And ask the questions where you can reach agreement, that's good. And where you can't reach agreement, I'll help resolve that. And then I would embody it in a short order, so that if anybody didn't comply or do what they were supposed to do, that I had some leverage to say, why didn't you do this? Because it is now a court order for you to do it. You actually agreed to the court order because we negotiated it. And now you have to explain to me why it wasn't delivered. And it facilitates the process, because my belief is that you're dealing with people that don't want to give you information, and they're going to make it as hard as possible for that to occur, even if the lawyers on the other side are trying to help you get the information that they know in their professional judgment that they need. The other strategy, which I think is really helpful, and this was a case against the judgment against an individual who had a company that had failed and owed a lot of money, and there was a judgment against the small company and against the principals, which would be individuals, and they went through this process of filing motions to compel, and had a motion, we had a hearing on that, and I said, well, what they've asked for seems reasonable to me. Why didn't you give it? And there was a lot of hemming and hawing. And so I said, I'm not going to argue with you, and I'm not going to listen to what all your excuses are. Here's what I want you to do. I want you to send me 3 months of statements for each of your bank accounts, and statements for each of your investment accounts, and for each of your credit card accounts. I don't want them all. I just want to see the statements. And then we're going to have a follow-up hearing. And at the follow-up hearing, and it's hard for them to say, well, that's too burdensome, because it's not, and they know it's not. And now they had somebody with some authority asking for reasonableness, for which they couldn't object. And the information we got just from those examples was a treasure trove. I mean, so I didn't have to go to a private school, to find out that they had paid $50,000 just a few months earlier for tuition for each child that was at the private school. And that was on the record. And then you could ask the question to say, I mean, you owe a lot of money to somebody else. Private schools are privileged. There's a public school that you could send your children to. Why are you continuing to send that money? And now I want to see where that money came from. And to me, I would say now it's easier for me to sanction somebody when I find out that that's the conduct in which they're engaged and their unwillingness to not give up anything that they have enriched themselves by fraud that they committed, because they continue to want to spend money and have the same lifestyle they had before they owed the money. That they knew at some point that something was going to happen to them, and they became cooperative. And it took me as a court far less time to resolve it and help the parties get to where they really needed to be than to have something going on that I don't get to see, which I know is expensive and ultimately is going to land on my desk to decide. So I would say that I think you've really got to, because I'm not going to do anything for you. If I've had to decide all of these motions and have been burdened by all the time that it takes to do that, my first question is going to be, what you've asked for is not reasonable. I mean, you opened the floodgates. You wanted every single piece of information and made no attempt to triage what it was that you really needed to at least begin. And if you begin and you can show me that it's been fruitful, then I'm going to be much more willing to help you, because you have shown me that you're trying to be reasonable, not only with your resources, but with my resources as a member of the court. And I want to urge everybody who's involved in this process to take a step back and say, what is it that we can do to show our reasonableness and to begin the process to show that we're not getting enough, because we now have information to show that there's more. It's easy to go after more when you can say, for example, look at this. We did get this little bit of information, but it was really helpful because now we know something about an account that we wouldn't have known about. Now we want information about that account. And I'm going to say, I can order that. Sometimes we just get too rule oriented and what can I do as opposed to what should I do?
I think that's great advice. I love the sample set, especially on as a creditor's lawyer, especially in the fraud context, we're very cynical and we think nothing, we get is an accurate sampling. But if we can dictate with like these 3 months, a random sample set for these 3 months, and if we see nothing there, then yes, we'd like a broader range of documents. And if you can't agree on that, then, pose the issue to the judge and see if the judge will be willing to look at the sample set. So I think that's a very real, helpful consideration that I will look to employ in my practice setting. You focus on, go ahead.
I'd say, well, the sampling is totally up to you too. So if I was asking for a sample, if I thought the fraud happened in, say, 2018 and continued up through the time that you ended up taking action to get a judgment against them, and let's say that's 4 years, I'd say, well, what is the representative sample that will help you test what was happening during that time? I'd say, give me the first 2 months of 2018, the first 2 months of 2019, the first 2 months of 2020, and let me see if there's a pattern that I can say. And nobody can say it's too hard to give you 2 months of statements.
I agree that, and if you have that in your good faith discovery discussion emails and, opposing counsel isn't agreeable to that, I think that's very telling if you have to go before the court. So very, very helpful information. And since you gave such practical guidance on that, I think most folks tuned in today to hear your views from as you transitioned your role into a mediator role, which Kevin Stein and I personally used you before, and we found you to be very effective, which is why we asked you to join our panel in part today. And so I'm sure you have a wide range of views on the effectiveness of mediation conferences and meetings. And I, for one, am a big proponent. Once you get to a particular critical point in your litigation, whether that's pre or post judgment. And so as a mediator, I assume you are equally a large proponent of mediation. Can you elaborate on some general views or practical considerations that our folks on the call might find helpful today?
I am a proponent of mediation, but I think you have to be thoughtful about when and whether you should mediate. First thing I'll say is that I do not think mediation is effective where it's been compelled. So if you have a court that compels you to go to mediation, that it's less likely. I mean, they come in saying, this is something we have to do. We're not, because it's not our idea, for example, because it's not our idea to do this, we resent that we're being told that we have to do it. And occasionally you'll get people to say, well, if we have to do it, let's see if we can make any progress. But compelled mediation, I don't think is the right time, the right way to get a favorable result. I will say that there are touch points in a matter where when you reach those touch points, that it makes more sense because it makes more sense because of the dynamics of the relationship between the parties. And for me, mediation is totally about all of the dynamics between parties in the context of a case that makes the difference, and which is my job to figure out and understand the dynamics, because that's the way you get a case resolved. So my view is that, there's some people that say you have to have a pending substantive motion before the court. Well, motion to dismiss, a mediation where a motion to dismiss is pending is not going to resolve the case, or a motion to dismiss where it's been decided. I mean, if it's been decided and it's dismissed, you don't have to mediate. If it's been decided and you're going forward, nothing's changed, so that's not a good point to mediate. The places where I think mediation is most effective, the critical times that you've mentioned, Katie, is this. Where you have a motion for such summary judgment that's been filed, and there's the uncertainty of the result that is pending, and people begin to think, well, if we don't do well on these issues, it's going to change what it is that we can ask for, or what it is that we'd be willing to offer. So the court has created anxiety for you by the fact that these motions are pending. And if in fact uncertainty is not viewed as, because you can't say, well, we're going to win. You can say, look, we don't know how we're going to come out with this. And because we both have something at risk, there's a sense of mutuality of people coming together to say, let's see let's see if in fact this is a time when it makes sense for us to resolve the case. As a mediator, especially with somebody that has a judicial background, that's a perfect opportunity for me, because I can speak in to say, well, here are the 4 issues that you have. And I can give you some sense on how the court is going to approach those issues. For example, to say, this is the sort of issue, the way that you framed it, is where a court's going to say, there are issues of fact to be decided, and so you're not going to get a resolution on that. And so you're going to have to wait until you get to a trial to find out how that gets resolved. But there are others where I'm careful not to practice law and all this, but I'd say I think a court will look at this issue by looking at these underlying facts to support your position, and your underlying facts on the other side to support the position. And I'd say if you were a court looking at this and you were faced with these 3 facts, do those favor you and not favor you? And sometimes, which I found really interesting, is that the client that's sitting there with them has never been asked that question. The lawyers have not said, here are the 3 things where we're strong and the 2 things where we're weak. And to have somebody neutral come in and say, I don't know how they're going to go, but here are the issues. Have you thought about what happens on each of those? Are you going to win them all? You're going to lose some? That they begin to think. That's all they do, is they begin to think about there's risk at this point. And it becomes just to have a neutral outsider identify those things that could constitute a risk for them. is new to them. And when you do it on the other side and you say, here are the three things I think that you're relying on. And then I'll say, well, here are the facts that you're relying on. Is that really, is this fact that you're relying upon really certain, or is it something that can be subject to interpretation? You just need to think about that. And the client saying, well, the client probably has had some anxiety to say, yeah, I know that we've got that fact, but it could be viewed differently than we view it. That creates a different relationship that the parties have had up until that point. The other thing that is I think incredibly important and really practical is, what are the other relationship issues that impact a party's desire to settle or not to settle? And often those are completely unrelated to the legal issues in the case. The lawyers that are willing to tell me about those are much more likely to have me be able to look at that and see whether there is something within a resolution that addresses an issue. And so here's an example. In a mediation, there was a dispute between a manufacturer of food products and somebody who had the responsibility for the machinery that processed the food to be sold. And it was and both the purchaser of the goods and the person that was going to process them were really good companies. And the lawyers that represented them were good lawyers. And the principals that I talked to were I thought, really people that were trying to do the right thing, but something had happened that they didn't expect. And what I found was that the unwillingness of one of the parties to engage the mediation process was because it was a younger person who had responsibility for the area in which they ended up in dispute. And the relationship that person had with their father was what was keeping him from being able to compromise, because he felt like he had let his dad down. And I think as a mediator, and I think as clients, that you've got to look at a client and say, what are the extrinsic relationship influences that impact the ability to reach a compromise? And I think the most fascinating thing about being a lawyer, and certainly the most fascinating thing about being a judge, was to set aside the legal issues and say, why did people do what they did? What happened here? What was it that you wanted to accomplish? Why didn't you accomplish it? And what were the outside influences that impacted that? And so in that case, I took the father aside who was at the mediation, and I explained to him, I said, I think the reason why we're not, because he was frustrated that we were not moving forward, but he was honoring his son's perspective and responsibility in the mediation. And I said, I think it's because he feels like he's failed you. And he said, you're kidding me. And I said, I just think he feels like he's let you down. And he said, I've seen him, this whole dispute, sure, I wish it hadn't come up, but I hate seeing him struggle to it. But he has grown so much through this adverse experience that he will be a much better steward of this company than I ever thought he would be. And I just told him, I said, you've got to have a discussion with him and tell him that. And then you got to end the discussion by saying that you love it. And an hour later, we settled the case.
That's amazing.
And I think the lawyers are not sensitive to that. I had a similar case where the lawyers came to me and they said, the impediment to this has nothing to do with money. I mean, we can get through the money part. The impediment is somebody who is trying to save face by not having it resolved today. And I said, well, I know that. But it's good to know that you know that too, because now I can deal with it. And this is all about people It's all about the motivations of why people do what they did. And there's always some extrinsic influence that is really the key. I'm a storyteller, so let me tell you one more story. This is a personal injury case involving the movie industry in Atlanta. There was somebody who was a stunt person, was a great at what he did, but had not done a lot of stunts, and was doing the stunt. During the stunt, he flipped on a motorcycle. The motorcycle is attached to this device, which is you need in order to make the movie. Falls, injures his leg, and his leg is amputated. So he's a young man married with one child, and of course the other side understood that it was a really sympathetic plaintiff who all he was doing what he was supposed to do, although they claimed that he was braking when he wasn't supposed to. But they knew it was a problem. The person, this is for the business people on the call, the person that was the impediment was the insurance adjuster. He was the company representative, which I took a little bit of, I didn't like the fact that the company representative was the person who was responsible for releasing money to pay a claim. And he just was not going to pay a claim that was large. And it was terribly frustrating to have him be the person that would say, we're not going to do that. We're not going to pay that much. And so at one point I told him, I said, you're in California, but do you know that the state of Georgia now, there's more filming in Georgia than there is in LA? And he said, well, I know that Georgia's strong because, we represent a lot of movie companies. I said, well, the state has done a lot to facilitate movie companies coming out and helping the economy in Georgia and making it worthwhile for companies to leave the hallowed area of LA and film movies in Georgia. And I said, I actually think, everybody's on this call. I said, I actually think your company probably feels good about the state of Georgia and the people in Georgia that participate in movie making. And I'm not sure for this person who got hurt, and the information was that it was the person who was the stunt designer who had made a mistake with the way that they had put together this contraption, and that's what caused the accident. And I said, I would like to talk to the general counsel of the production company. He said, oh, well, I'm not going to let you do that. I said, well, you're really not the client. But I do want to talk to them about whether or not they would see some merit for an issue that goes beyond actual money, in which they would be interested based upon their ability to make movies in Georgia. And he said, I know them. I've represented them for a long time. He was a lawyer, by the way. And he said, I'm just not going to let you do that. And so we ended the mediation. Actually, I suspended it. And I told the lawyers on both sides, you need to ask to talk to the general counsel of the company, the production company, the movie company, and explain to them what happened and see if they are concerned about whether or not this is going to erode their goodwill in the state of Georgia for making movies, that this person's terribly hurt, and that there's an unwillingness to pay more money than's on the table. And they said, well, we'll see if that we can do that. In the meantime, I spoke because his wife was there. And so and I knew how this had impacted his life. And I just asked him, I said, are you going to do any more of this? He said, I'm not. I can't run the risk of impeding my ability to make money to support my family. And I get a call. They said, well, because we left with an offer on the table. I told them what I thought the number was that could actually resolve it. And they called back. This was on a Friday. They called back on a Monday. They said that they had in fact that morning called out to California to talk to the production company, and the president of the company was asked about what he wanted to do by the general counsel, and the president of the company said, "Pay him. I didn't know that had happened. I feel terrible that that happened to somebody who was helping us make a movie with a star for which we made a lot of money. Tell him I'm sorry and pay him what he wants." And that had nothing to do with money. That had everything to do with understanding the relational issues, business, reputational, in the case of this young man, he and his family, and knowing that at the end of the day, this finally somebody who had some reason said, "I want him to have enough money to get a new start in his life." And lawyers and clients need to take those into consideration because that's what makes a difference.
Thanks, Judge.
And
I think those are all very helpful. Go ahead.
You have to cut me off because I will.
Sorry, I didn't mean to cut you off. I was going to say our bank clients on the call, I think that, what I find as far as intrinsic considerations that are often at play in these mediations, apart from the numbers and the bad acts, are, in the cases that involved some complexity of fraud, you have the banks, that want to pursue these bad actors so that the world knows and other bad actors know that they are, going to pursue these, fraudulent loan transactions. And then you sort of compare that against, often in these fraudulent matters, you have the bad actors pointing the finger back at the bank in some capacity, saying whoever, whether it's the loan officer, the salesperson that pitched the loan, or a special assets person that was working the loan out, that they knew about sort of this transaction and for whatever aspect of it. And so there's some type of allegation of that someone at the bank knew, and while that's not a valid legal defense, regardless of whether there's evidence to support such a claim, we struggle in these conversations with bank clients about that these might come up at trial, and we don't want that reputational risk out there. So I hear you on balancing the sort of those extra considerations, and they're often at the forefront of these mediation discussions. So I wanted to touch on, Lacey and Kevin, sort of as we go through these transactions that have fraud, often these fraudsters are sophisticated and will attempt to, hide assets either via a new co, and I'll let Lacey describe what that is if she can do that in like 2 minutes or less, or, how we sort of identify transactions that are to what we would call insiders and how we might otherwise call those back. So looks like we only have about 2 minutes left. So we'll sort of preview those topics, and perhaps there'll be yet another webinar to discuss those topics more in fulsome detail. So with that, I'll let Lacey perhaps have a minute and Kevin with a minute, and then we can conclude.
Yeah, it's a whole nother webinar if we're going to really dig deep on that. But suffice it to say that there are plenty of remedies out there for creditors that are kind of find themselves in that position. Multiple states have some form of alter ego and/or single business enterprise or successor liability case law that enables effectively to disregard the corporate formalities and go after an entity that perhaps you do not have contractual privity with because it is in the alter ego of your judgment debtor, or is acting as a single business enterprise with your debtor. It's highly fact specific and it varies across the different jurisdictions, but it is something that effectively sounds in equity. And the reason that these types of remedies exist is to prevent fraud and manifest injustice. So tune in for the third one of these when we really dig into that at a future date.
Thanks, Lacey. I agree. They're often quite fact sensitive. And Kevin, do you have a second just to preview a potential future conversation on fraudulent conveyance or transfer lawsuits?
Sure. And similar to alter ego, theories, fraudulent conveyance issues can be easily discussed in an hour or more. I'll tease the group with two examples that we'll touch on in a future webinar. We typically think of fraudulent conveyances as a transfer of money or a transfer of property by the judgment debtor, but I'll give you two instances where it can come up in a different context. One is I've seen a judgment debtor incur debt or allegedly incur debt as a way to evade creditors. And specifically, I've seen judgment debtors put mortgages on their own property, identifying a related party or a friend as the mortgage lender. And there's tools for stripping those kinds of mortgages from a property that might otherwise be available for a judgment creditor that has a junior lien on the same property. And then the other example is in closely held companies where I've seen judgment debtors withhold or cause the company to withhold making proportionate distributions or dividends to that judgment debtor and essentially hold back those distributions to keep those proceeds from the hands of a judgment creditor. And we'll address that in a future webinar as well.
Thanks, Kevin. Just as a reminder, I'll let everybody go in about 30 seconds. Attached is our office presence. We've recently expanded to the Northeast, so I do want to highlight that. And I did see we had one question submitted. We'll be sure to connect with you afterwards about your tenancy and the entirety's question specifically pertaining to Florida. So thank you to everybody so much for joining us. We'd love for you to connect with us. And with that, I'll wrap up and look for more information from us on future webinars concerning this topic. Thanks, everybody.